Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I'm VP Moolman from Maserumule, and in today's episode we will unpack what if an employee who uses cannabis for cultural reasons is blocked from entering the workplace. Does the failure to allow him to work amount to unfair discrimination? Now, as you are aware, back in 2018, our Constitutional Court in the Prince matter effectively legalized the private use and possession of cannabis. Post this judgment, employers were concerned about the effect of the judgment on workplace policies, specifically those regulating substance abuse, including the use of cannabis. But we have seen in recent times arbitration awards and labor court judgments confirming that employers remain empowered to set workplace policies regulating substance abuse. Now, the matter I will be discussing in this episode is the matter of Maserumule versus Petroleum, Oil and Gas Corporation of South Africa, also known as Petro SA. Now, in this matter, the question before the court was whether a substance abuse policy can be discriminatory in cases where the employee is using cannabis in private for cultural reasons. As always, let's start by discussing the facts. Now, in this matter, Mr. Maserumule is employed by Petro SA as a telecommunications technician. In 2019, he informed Petro SA of his intention to pursue his calling as a traditional healer, which would involve the use of cannabis. Now, in order for him to attend his training school located in Mossel Bay, the company allowed him to transfer from the Cape Town branch to the Mossel Bay refinery. He was subsequently tested for cannabis, and the results indicated that he was above the permissible cut-off levels in terms of their substance abuse policy. This meant that Mr. Maserumule was deemed unfit for duty and he was barred from accessing the refinery. In terms of the company's policy, he would only be permitted to return when he tested below the threshold. Mr. Maserumule was consequently away from work for a period of 3 months, and during this time he was made use of his remaining annual and sick leave credits. The employee, Mr. Maserumule, was of the view that his absence from the workplace amounted to an unfair suspension, as he was obliged to make use of his remaining leave days during the period of absence. He further argued that Petro SA's cannabis policy led to unfair discrimination on the basis of culture, and lastly, he argued that Petro SA acted unreasonably in dealing with his spiritual and cultural journey and thus failed to provide him with reasonable accommodation. So, at the Labour Court considering the employee's arguments, the court acknowledged the potential unintended discrimination that drug and alcohol policies might bring about for certain cultural groups. However, the court emphasized that determining whether such policies amount to unfair discrimination hinges on assessing whether the policy serves as a response to an inherent requirement of a specific job or job role, such as managing inherent risks connected to substance misuse. Now, in light of Petro SA's operational context, it focuses on oil and gas exploration and the legal prerequisites for health and safety, the Labour Court concluded that the policy establishes a bona fide and rational requirement aimed at promoting a safe and healthy work environment. Consequently, it becomes crucial to consider the overall work environment in addition to the specific role held by an employee within the organization. The Labour Court underscored that all employees were subject to standard workplace regulations in this regard. In terms of the employer's duty of reasonable accommodation, the court examined the various measures taken by the employer to facilitate Mr. Maserumule's traditional training pursuits, including authorizing his relocation and granting an extension of his tenure at the Mossel Bay refinery. The evidence presented further highlighted the employer's considerate and empathetic treatment of Mr. Maserumule's situation. The Labour Court went on to affirm the principle that an employer is not obligated to provide accommodation to an extent that would be deemed unreasonable or would place undue hardship on the employer. The court further found that barring Mr. Maserumule access to the plant when under the influence of intoxicating substances did not constitute a suspension in terms of the Labour Relations Act or an unfair labour practice for that matter. In this regard, the court held that the concept that an employee should not be immediately barred from entry into a petrochemical plant when an impermissible amount of an intoxicating substance is found in their system is absurd in the court's view. Further, the employee had applied for sick leave and annual leave for the period he was unable to enter the workplace. Now, the court did accept that Mr. Marasi felt deeply about the issue and was genuinely aggrieved by the policy. However, the existence of discrimination does not depend on a person or group's subjective feelings. The court accordingly found that the employer's request for Mr. Marasi to vacate the workplace did not amount to an unfair suspension, but a reasonable application of company policy. So, ladies and gentlemen, in conclusion, the judgment simply affirms the legal stance that substance abuse policies can indeed restrict or curtail cannabis consumption by employees as part of an employer's endeavor to establish a safe work environment. Importantly, this case again underscores that these policies will not be deemed unfair discrimination if the employer can demonstrate that adhering to the policy aligns with an inherent job requirement. So that then brings us to the end of this week's episode. Thank you for joining us. We hope you have found our discussion informative. If you have any questions or comments on this topic, we would love to hear from you. You can find us on social media or email us at info@massconsulting.co.za. If you are interested in staying up to date with the latest news and insights on employment law, be sure to subscribe to our YouTube and Spotify channels. I will see you next time. Bye-bye.